Jonathan Emmons on behalf of the people, Your Honor.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Caminita. Your Honor, I see Mr. Caminita was present. I do not see him on the camera right now. I know that he's in a
Court calls the case People versus Dolores Strickland.
Ready,
Kirby
Judge.
on behalf of the people.
Court shall cease to Assistant Public Defender on behalf of Miss Dolores Strickland. Miss Strickland, please state your name for the record. She had been here.
He is here, but not in the camera.
And Your Honor, can we briefly approach?
Seriously. Yes. You knew. I think I'm back. Are they back?
Yeah.
All right. On this matter, record should reflect you've had a brief bench conference. Miss Kirby.
Your Honor, during the break while the court was taking an hour recess in between cases, it appears that the defendant and the victim were on screen, obviously violating the no contact order. They were doing non-appropriate courtroom things, and the people are asking, giving the violation in the court and the violation from community corrections as well, that the defendant's bond be revoked and she report to the jail by this evening. If not, I would ask for an immediate bench warrant to go out. I know there's a bench warrant already with no bond out of community corrections.
Yes.
Judge, for the record, I have spoken to Miss Strickland about 3 times over the last couple of days. I did notify her about that community correction warrant. I did tell her that she should turn herself in on that warrant. She has not done that at this point. I do not know if she intends to do that. I will accept Miss Kirby's representation that that was the alleged victim. On screen was her, Your Honor, and she already has a warrant to turn herself in, so I would ask her to do that on that case anyway, in addition to whatever the court does on this file, Your Honor.
All right. Miss Strickland, can you come to the screen? She was here and then she's been out walking around, smoking, as well as doing the things that I could be more descriptive of than Miss Kirby, but certainly it involved contact with the victim in this case. She's not on screen at this point, but what the court's going to do is the court is going to leave the other bench warrant out, no bond. I've marked the file that I did witness, presuming that to be the victim in the case, and I will trust that representation that's being made. I did witness them together, which would be a violation or an additional violation of her bond. So I will leave the bench warrant out. I'm not going to set a new date. I think we know where she is, so we can potentially send somebody to get her. All right. Thank you.
Thank
Thank
you.
you, Judge. Thank you, Miss Kirby.
Court calls the case People versus Jonah Witt. When I tried to call it.
Include me on any bench conference with Caitlin Kirby. I would just really appreciate that moving forward.
What?
I said, can I be included in all Caitlin Kirby bench conferences moving forward? I would really appreciate that.
No, that one was pretty ugly. It was not.
Nicole Hughes on behalf of the people.
Court calls the case People versus Christopher Caminita.
Jonathan Emmons on behalf of the people, Your Honor.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Caminita. Your Honor, I see Mr. Caminita was present. I do not see him on the camera right now. I know that he's in a supportive living situation, a sober living situation. So I don't know if something happened, but I would be asking for an adjournment.
Did you have him?
He's here, Your Honor. I've been kind of keeping an eye on him. He's slowly been drifting further and further into the couch. I think he might be asleep.
Oh, he does work too, so he might be tired.
You know what? Whenever something happens like that, Miss Gaines always has something to say. She is
Positive, positive to say.
she was not going to deny that he was asleep. She's just like, well, there's a reason. All right. I'll grant the adjournment. He's here.
Kind of.
Unless there's an objection.
No objection, Your Honor.
Yeah, right. September 28th, 2023, 9 a.m. That way he can get some rest. Bond continued. All right, thank you.
Thank you.
Calls case, Other People versus Sheldon Underwood.
Nicole Hughes on behalf of the people.
Andrew Banis, Assistant Public Defender, with and on behalf of Mr. Underwood. Mr. Underwood, please state your name for the court.
Sheldon Underwood.
Frank. What are we doing?
Your Honor, Mr. Underwood has two requests. One pertains to bond, but the first request is for a 1-week adjournment to hire private counsel. He informs me that his family has already reached out and is in contact with one of the local law firms.
Are they going to be able to accomplish that in a week?
I did discuss that with him, and he believes so.
All right. I'm only going to adjourn it. Well, I'm going to adjourn it to the 21st, if that's what he's doing, because he's only going to get one adjournment to get counsel. So probable cause conference, September 21st, 2023, 9 a.m. Or Zoom invite indicates yes, ask the bond.
Thank you. Mr. Underwood is currently held on a $200,000 bond on this case, no other cases. He is requesting a reduction to a 10%. That's still quite significant. I understand the charges are serious in terms of the fleeing, and there's also a third count relating to the vehicle. His main concern is to get back to work if that $20,000 bond could even be posted and continue making his child support payments.
Response?
Your Honor, please let me know when you're convinced and tell me to stop talking because I could go on for days about this one. First, the defendant does have another, he does have another case. He has a friend of the court bench warrant right now. So in terms of him wanting to continue to pay his child support, he's got a bench warrant for his arrest for failure to support. He right now, the bench warrant has a bond of $536 for past due payments. The defendant's bond is set in the amount of $200,000. I charged this case. I requested $250,000, and I am renewing that request at this time. The defendant took multiple interstate police agencies on a high-speed chase beginning in Toledo, Ohio. He fled from Toledo all the way up to Ann Arbor. The third charge that Mr. Banis mentioned, the thing that involved the vehicle, that was when the defendant drove his car directly into a Pittsfield Township occupied patrol car, which is an FA on a police officer. The defendant was fleeing from Ohio with an Ohio State helicopter following him into Ohio. Pittsfield, the Washtenaw County Sheriff's Office, as well as Ann Arbor had to get involved in this chase. He was doing speeds as fast as 114 miles per hour on Michigan Avenue. He wasn't, not that that's even part of a speed limit, but he wasn't even on a highway when he was doing 114 miles per hour. In terms of him being a danger to society, his reckless fleeing and his intentional assault on a police officer while fleeing certainly demonstrates that he's a danger to society. And then, of course, he's a flight risk given that he took multiple jurisdictions on an interstate police chase. He ditched his car on US 23, tried to get out and run. When the police found him, thankfully, he was compliant and didn't continue to assault them. And they were able to take him into custody at that time. He is... when they searched his vehicle, they did not recover a firearm, but they did recover a magazine that was empty, did not have any ammunition in it. Again, the people are requesting at this time that his bond be increased to the initial request of $250,000.
When he rammed the Pittsfield officers, were any of the officers injured?
Thank goodness they were not. The officer was not injured. His car was, His car was damaged to the extent that he was unable to continue to pursue the defendant, though.
May I make two very brief minor points?
Go for it.
First, at least according to X jail, I think the front of the court warrant has been resolved, but Ms. Hughes might have some information that I'm not aware of. As I read the police report, and this is no doubt a factual dispute, but as I read the officer's statement, and I'm not blaming the officer in any way, but as I read that statement, the officer hit the defendant's car. Now, how that happened, but that's how I read it. And I'm not
Does
saying
that help you? They're on a high-speed chase from Ohio. So the officer hits his vehicle, maybe to stop it and save other people. I'll let you go on, but go ahead.
No, that's it, Your Honor. Thank you.
Motion for bond reduction is denied. I will, and quite frankly, given the circumstances laid out by the people, I think the $200,000 bond is set very low. I don't even think that the $250,000 bond is appropriate, because from Ohio to Ann Arbor, all of the individuals that would have been on that roadway, as well as once he got himself on Michigan Avenue doing those high speeds, he put all of those people in danger. He put all of the officers that had to pursue him in danger. And for no reason. And at any given point in time, given those speeds, somebody who could have been just out could have been killed. Court will set bond in the amount of $500,000 cash surety.
Thank you, Your Honor.
Michigan versus Raymond Honeycutt.
Yes, sir.
Good morning, Your Honor. Allie Zend on behalf of the people seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Permission to practice is granted.
Good morning, Your Honor. Gina Noveski, First Assistant Public Defender, on behalf of Mr. Honeycutt, who is present.
I have not had no contact with my attorney, sir.
Yes, sir. Let me explain that. Your Honor,
yes.
I did try to contact Mr. Honeycutt as instructed by MDOC. However, when I called, I got a message that they were under emergency immobilization. I tried calling multiple times and could not get through. So I do apologize to Mr. Honeycutt and the court for that. But we would
So it
need
was
to.
something having to do with the facility, correct?
Yes, that's my understanding.
Okay. So you would like an adjournment of this proceeding?
Yes, Your Honor. And I did request any video from Ms. Kirby as well.
Yes, excuse me, Miss Geneva. Yes, I'd like to talk to you, please. Let's speak to you.
Ma'am, sir, did you just hear what she said?
No, yes.
Did you just hear what she said?
No, I didn't hear. I didn't hear you.
I didn't think so. You weren't listening. What she said was she tried to contact you in accord with MDOC procedures. There was something with the facility. Just listen to me, because otherwise I'm going to be done. I'm just going to give you a date. I'm going to try to explain it to you. She tried to contact you, could not get through, and she apologized to you, but it's not her fault that she couldn't do it. So she's asking for an adjournment so that she can arrange a time to talk to you about the case.
Yes, sir.
Probable cause conference will be adjourned to September 28th, 2023, 9 a.m., or as your Zoom invite indicates, bond continued. Thank you. Cases of the people versus Nicole St. Germain.
Ready again, Judge.
Good morning, Your Honor. Nicole Hughes on behalf of the people.
Portia Feaster, again, Assistant Public Defender on behalf of Ms. Nicole St. Germain. Please state your name for the record, ma'am.
Nicole St. Germain.
Thank you, Judge. At this time, there wasn't an offer on this file. Based on that, Mr. St. Germain is asking that we have these matters set for preliminary examination, please.
Preliminary examination in person will be set September 19th, 2023, 9 a.m., and that is before Judge Fresh Hour.
What? This is
I'll let her know you said who. That would be Judge Anna Fresh Hour, man.
I was supposed to be let out today.
No, ma'am. No, ma'am. We're setting it for exam, and then we'll try to resolve it at that point and try and get.
What does that mean?
That's what we discussed, where we're going to set it so the witnesses have to come to court to testify, or we can resolve it with a plea.
I thought if they didn't come today that you could resolve it with a plea.
No, ma'am. That's at exam.
So wait, what's happening?
Okay, I'll come see you again and we'll talk about it again.
Oh no, I'm just wondering because you told me that if they didn't show up for court today that it would be dismissed.
No, ma'am. I said a preliminary examination. Cases are often dismissed if the witnesses do not appear. But we can talk about it. I'll
No,
come
it
see
doesn't
you.
appear.
All right, Nicole, come on.
All
Are
right.
you guys done?
I'm sorry, Judge.
Okay, no, it's okay.
Yeah,
Because I was
the
going
courtroom saw a
series of shocking
to let you go.
But one
Okay,
case stayed
I
out of
appreciate it,
above the rest.
Judge.
A defendant
Saint
ignored
Germain,
a
I'll come see you
court-ordered
again. Your next court date is
no contact
9/19.
only to be caught
Okay,
interacting
well,
with the
what?
alleged victim
I
during
just
a
that's not
live
really what we
court
talked
session.
about.
The judge immediately treated it as a
Thank
serious
you, Your
bond
Honor.
Thank
violation,
you.
leaving the arrest warrant in place. In another dramatic hearing, a suspect accused of leading police on a dangerous high-speed chase across state lines saw his bond increased to $500,000 as the judge emphasized that reckless actions put countless innocent lives and law enforcement officers at risk. Throughout every case, one message remained clear. Courtroom rules are not optional, and judges will not hesitate to act when defendants ignore the law or endanger public safety. These hearings serve as a powerful reminder that every decision made before the court carries real consequences, and accountability always comes first.